While the Gyanvapi mosque case is being heard in a district court in Varanasi, there's another fight for another temple going on in a district court in Delhi. And this is not for one, not for two, but restoration of 27 temples within the Quwwat-Ul-Islam mosque inside the Qutub Minar complex. But in this case, it is the Archaeological Survey of India which has come forward and said that no puja can happen inside Qutub Minar. So in today's episode of KYC, I'll tell you what this case is all about and why the ASI doesn't want any puja inside the Qutub complex. So now basically the ASI has filed an affidavit in a Saket court saying that the Qutub Minar is not a place of worship and that nobody can claim a fundamental right to worship in a centrally protected monument. The affidavit has been filed in response to a petition that wants restoration of Hindu and Jain gods or deities and the right to worship within the Qutub Minar complex. I'll tell you more about this petition in a little bit, but the ASI has come forth and has even said that nobody is denying the fact that there are a number of sculptures existing within the Qutub Minar complex. According to the affidavit, architectural members and images of Hindu and Jain deities are reused in the construction of the Qutub complex. It said that this is very clear from the inscription in the complex which is open to public viewing, which is actually true. The inscription at the Quwwat-Ul-Islam mosque in the Qutub complex clearly says this. You can see the translated text on your screens right now. So the affidavit acknowledges this, but it says that allowing any person to claim a right to worship in a protected monument would be contrary to the provisions of a law. Provisions of the Ancient Monument and Archaeological Sites and Remains Act 1958. Let me tell you that the mosque within the Qutub Minar complex was in fact declared a protected monument way back in 1914 and is now a protected monument under this 1958 Act as well. And section 20A of this 1958 Act actually makes the area, I quote, beginning at the limit of the protected area or the protected monument and extending to a distance of 100 meters in all directions as a prohibited area. Nobody other than an archaeological officer can actually carry out any construction in this entire prohibited area. So relying on this law, the affidavit says that the intention of the law is very clear, that the monument should be protected and preserved in its original condition. And since Qutub Minar is not a place of worship and no part of it was being worshipped when it was protected, its character needs to be maintained. Basically, they said that once a monument becomes protected, its character gets frozen in time. Now, what has happened is that a civil suit was first filed in Delhi's Saket court. This was filed on behalf of Hindu deity Lord Vishnu, Jain deity Tirthankar Lord Rishabdev and a few others. It had contended that Qutb-ud-Din Aibak had dismantled, desecrated and damaged Sri Vishnu Hari temple and 27 Jain and Hindu temples to then build the Quwwat-Ul-Islam mosque in the Qutub Minar complex. They had relied on their fundamental rights under Articles 25 and 26. Article 25, as we know, guarantees the freedom of religion, freedom of conscience and free profession, practice and propagation of religion. And Article 26 talks about the right of a religious denomination to manage their religious affairs. So they had relied on these two rights. Now last year in December, civil judge Neha Sharma had rejected this suit, writing a judgment that spoke of India's rich history. Her judgment said that India has a rich history and has been ruled by numerous dynasties. But she went on to say that, and I quote, "Nobody has denied the wrongs that were committed in the past, but such wrongs cannot be the basis for disturbing the peace of our present and future." She also said, and I quote, "Our country has a rich history and has seen challenging times. Nevertheless, history has to be accepted as a whole. Can the good be retained and bad be deleted from our history?" This is what the judge asked. Now, Judge Sharma had also referred to the Places of Worship Act 1991, which is being spoken of about a lot these days. It basically preserves the religious character of a place of worship as it existed on 15th August 1947. This law, as we know, prohibits conversion of places of worship like churches, mosques or temples to a place of worship of a different religion. Now, this is the order, Judge Sharma's order, that has now been challenged before an additional district judge in Saket court. This court heard the arguments of all the parties, and the judge Nikhil Chopra has reserved his judgment. During the arguments on Tuesday, the court said that the most fundamental question is of character, because ASI on one hand has argued that the character of the mosque was frozen after it came under the protection of the 1958 Act, while the petitioners have claimed that the religious character must be considered since this was a temple before it became a mosque. The judge even asked the lawyer for the petitioners, and I quote, "What the important question is, can you now claim it to be restored and under what basis? Now you want this monument to be turned into a temple, calling it restoration. My question," the judge said, "is how would you claim that the plaintiffs have a legal right, assuming it existed about 800 years back?" Now, just to let you know, the final judgment on this case will come on 9th June. So we'll keep an eye out for that. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on social media.